Today we are talking about intellectual property with a specific use case of how to use intellectual property for protecting t-shirt designs. I'm going to address mistakes that entrepreneurs make when establishing a brand for t-shirt based on a design or artwork, and how to avoid these mistakes and protect your intellectual property. I am Wayne Carroll, a patent and trademark attorney. There are different types of intellectual property rights. Patents, trademarks, copyrights, and trade secrets. With patent rights, you often see patent pending, which is one way to indicate you are claiming rights to a product, design, or invention. Trademarks can be marked with either circle R or TM. Copyright marking is a circle C, and trade secret is marked confidential. Patent rights are for new machines, new materials, and new things that function in some way. Usually, we would not be looking at a patent to protect a t-shirt design. If a company has a new machine or a new material, we might look at patents for protecting rights. But here we're talking about t-shirt designs, so I would not recommend patent protection. Trademark will often be a big part of the intellectual property strategy for a t-shirt company. Trademark is about protecting a brand. We will talk more about what qualifies as a brand and what does not. Copyright protects your unique creative content. Copyright law prevents people from copying your creative work for something you've already created. Creative works includes books, sculptures, pictures, videos, and artwork, to name a few. Creative works are protected with copyright. And then trade secrets are valuable ideas that you keep secret. If the idea is shared with someone, then you need an agreement to keep it secret. Everything starts as a trade secret because when you have an idea that gives you a competitive advantage, you keep it secret until it's protected, or you've already gained the advantage from the idea. For a t-shirt design, we're going to look at trade secret, copyright, and trademark. A trade secret for a t-shirt design may include the design itself, at least until the design is published, a marketing plan, vendors' names and terms, customer lists or contact lists, business plans, market research, and other confidential information that is not public that you can keep secret. A good contract is needed to keep the idea secret, and you need reasonable security to prevent people from stealing your trade secret. Many businesses start in stealth mode while they're gathering information and planning. And at this stage, everything you do is a trade secret. You can get copyright rights for logos and artwork that you have developed yourself. If you have short sayings that you want to put on t-shirts, copyright can be a challenge because short sayings of the length that would usually go on a t-shirt are not eligible for copyright. Original pictures or artwork, however, are protected by copyright rights. You can claim copyright rights by marking your art with the circle C, the year, and the owner of the copyright. For example, I have at the bottom of each slide here, copyright 2021 Inspired Idea Solutions, LLC. When you have a piece of artwork that is selling, I recommend that you file for a copyright registration in the United States Copyright Office. You are not required to file an application to register a copyright, but there are significant advantages to filing. So to explain the use of a t-shirt design, I've created an example brand called I Love Ducks, with a picture of a duck with side borders. My brand is for those who love ducks and don't want to hunt them. So the shirt color is bright, and the brand on the shirt, though, is not enough just being on the front of the shirt to get a trademark registered, because it's not clear that the image and words are functioning as a trademark. The Trademark Office is working to protect against people who register brands without actually selling them. They are actively trying to stop squatters for brands. So in this case, I didn't actually make this t-shirt. I created this t-shirt design from a website called Custom Ink. The image is a mock-up of the t-shirt, even though it looks like somebody's actually wearing this t-shirt. My design is from a stock image of the duck from the website and has the words, I love ducks. Since I did not have original artwork, the copyright protection I can get would be minimal. But what do I need to do to protect the design as a trademark? To get a federally registered trademark, you must actually use the design as a trademark, not just as artwork. You can file a trademark application without using it as a trademark, but before you're finished with the trademark process and granted a registered trademark, you must submit proof of use as a trademark. The digital mock-up is not a trademark use because it is not an actual sale of an actual product as a first reason. And this is a mistake or a shortcut people try to make, but it doesn't work. The trademark office is very aware of the ability to make mock-ups versus actually having a product that you're selling. So where the trademark office wants to see the logo you're protecting is use on an actual product. For example, a hang tag that shows the logo may be trademark use. This picture is actually a mock-up hang tag, but if I were to order that shirt and this hang tag, and I wanted to submit proof to the trademark office that I'm actually selling t-shirts with this brand of the duck logo and I love ducks, I would actually attach this to a shirt and take a picture of the hang tag attached to a shirt. It is the hang tag that says who you are buying from. A trademark must indicate who you are buying from, not what you are buying. So in this case, Vistaprint is the website that I used, and it's a website where you can get stuff printed. It's not very hard to create what you need, but you also have to make sure you are actually selling the product with the logo you want to claim as a trademark. You can sell through a website, but the danger is if you're not actually selling, if you just put up pictures, or if you don't actually have it offered like with a cart, and it's just a mock-up, then that's not going to be considered trademark use. If you're using a website to sell, then you will want the logo to be the main logo on the page of that website, not just a logo on a shirt. If you have lots of different designs and you want to protect each of the designs, it may not be practical to protect each design as a trademark. Rather, select one as the brand, and the rest can be protected with copyright rights. Once again, the brand needs to indicate who's offering the t-shirt in order for it to be actual trademark use. In this case, the name of the company is the Calm Pond Company. And this is a fictitious company I've made up. If someone sees the I Love Ducks logo, we want them to think of only one company, the Calm Pond Company. Now you got to say the name of the company slowly, as that's part of the brand. Anyways, using the logo as a brand is a big difference between use of a design on the front of a shirt. For my fictitious company, we will put the logo on the hang tag and sell a whole line of different duck images, but we will always use the same logo on the tag, on the hang tag with I Love Ducks. This is what it takes to create a brand. You can sell a single design on the t-shirt to establish a brand. So in other words, if you only have one t-shirt, it's going to be harder to establish a brand than if you're lots of t-shirts, but all using the same logo on the hang tag or somewhere that indicates this is who you're buying from. I hope you enjoyed this video on protecting intellectual property rights for a t-shirt company that sells t-shirts with the designs. If you like this video, please use the links in the description to subscribe to our newsletter, follow us on Facebook, and connect with us on LinkedIn. You can always contact us for help with your intellectual property rights. I'm Wayne Carroll, founder of Inspired Idea Solutions Law Firm. Thank you.